National Congress Reform, DNCR, presents Nationwatch.
Hello Guyana and welcome to another edition of Nationwatch for today, 18th September 2022. We are going to have a very interesting conversation today. We're going to be bringing you some updates with respect to legal matters, and here to bring that information to you is Mr. Roysdale Ford, my guest. Mr. Ford is Senior Counsel, Member of Parliament, and Shadow Minister of Legal Affairs and Attorney General. Interestingly enough, Mr. Ford seems to be casting quite a huge shadow himself, which seems to be covering the subject minister. Welcome, Mr. Ford.
Thank you very much, Morgan, for inviting me.
It's great to have you. Somebody was telling me the other day that they can't recall having seen a man's shadow destroy him so often. Now, Roysdale, we have a interesting situation that is on the minds of many Guyanese, perhaps most Guyanese. This gentleman, Mr. Nandlal. Mr. Nandlal is an agent of the People's Progressive Party. He is a candidate for the People's Progressive Party at the 2020 regional general elections. He served as agent for a voting district that in large measure contributed to the problems that we had in the last election, where 47 boxes were found to have been compromised, void of relevant source documents. Now Mr. Nandlal holds political office, and he has written to the Guyana Elections Commission requesting some information which was passed to the Commission by the APNU-AFC. As I understand it, the APNU-AFC's agent, Mr. Harmon, had written to GCOM identifying on two lists persons who were believed to have been out of the country on the one hand and dead on the other hand, but whose name turned up on the voters' lists with evidence that suggests that they had voted. Now Mr. Nandlal, using his political office, sought to and received these documents. How reasonable is a request like this from Mr. Nandlal, given his background, given the offices he holds? And how lawful is the Commission's honoring of his request?
Well, Marvin, the issue that you've asked is a critical issue which I know is informing a number of discussions across the country. We first have to understand and look at the request of Mr. Nandlal, exactly as how you put it, but within the wider context of the effort by the PPPC to not let the citizens of this country really know the truth of what would have transpired in the elections. But I'll start with something that they cannot dispute up to now. And what they cannot dispute is first that Mr. Harmon wrote the Guyana Elections Commission a number of letters, really more than 2 letters, addressing the issue of the voting of persons who were not in the country at the date of elections, and for which the Elections Commission itself had evidence that those persons did in fact vote. What is undisputed, Marvin, is the fact that the chairman of the Elections Commission, based on the communication that we have now received, wrote the chief immigration officer, who's the commissioner of police, and received confirmation that as a phenomenon did occur and did identify many names, indicating that what the APNU AFC wrote in the letter to the members of the Elections Commission, wrote to the chairman of the Elections Commission, was in fact confirmed. So we wrote the chief elections officer indicating during the period of the recount that this is what our information had revealed. So that is a fact. So moving from that Marvin, the effort by the government, Mr. Ali, to appoint a commission of inquiry, the effort by Nandalal to request this information, and most recently to seek to instruct the Guyana Police Force to engage in an investigation into the very material which the Guyana Police Force already would have confirmed, is not only comical in one sense, but it goes to the point of establishing clearly that they're seeking to discredit the information that we would have provided, and they're seeking to discredit the APNU AFC and the evidence that we would have produced to establish that these elections were far from credible. So we must understand what they're trying to do. We must understand what is their agenda. And this agenda that they have contrived or arrived at must be understood in the wider context of the elections petitions. You asked me also about the legality of what Mr. Nandalal is undertaking to do. I believe it is unlawful. I believe that as a sitting Attorney General, as a member of the PPP, as a member of the central executive of the PPP, as also somebody who would have been in the affairs of an agent or managing the PPP's elections right in the very region of Region 4, which was the hotspot of illegality and anomalies that would have been unearthed during the recount process, ought not to have been in such a position to write asking to receive information that he wishes to confirm. But the other dimension of it is that Mr. Nandalal could write. The problem that we have also now, it lies on the part of the Elections Commission itself, where the Elections Commission, rather than seeking to engage in an analysis and an investigation of the conduct and the management of the 2020 elections, which is something that our commissioners have been asking repeatedly for the commission to do, the commission seeks to absolve itself of any responsibility in relation to the product of the elections that they held, and simply to say that they don't have to be part of that process. They don't have investigating powers. But at the time when the letter from Nandalal would have been received by the commission must have known, and did in fact know, because the communication exists now, to show that they knew at that time that the claims, the positions and allegations of the APNU AFC were highly meritorious, and there was nothing that Mr. Nandalal could now investigate.
Two things that jump out at you as being interesting here. Nandalal writes as Attorney General, not as agent of the People's Progressive Party. Is this a case where Nandalal seeks to use an official executive office to intimidate the Guyana Elections Commission? And did the chairman in fact bow to that attempt at intimidation? And secondly, we learned some time ago, I believe it was last Sunday, Mr. Alexander was here on this program, and he in fact said there are three sets of records. The first set is where Mr. Harmon wrote as agent of the APNU AFC, supplying names and making a complaint. And secondly, a set of documents which GCOM used to submit to the relevant agencies as you've outlined, the Chief Immigration Officer and the Registrar of Births and Deaths, and return information from those two statutory agencies, confirming, as you have already pointed out, the veracity of the majority of the claims made. Now, why would Nandalal want to ask the police to investigate again? Is this a political circus, or is it an attempt to provide now false information to place in a bad light a former commissioner of police and a former, who's now retired, and a former registrar of births and deaths who was fired by the same government that Nandalal represents?
Yes, Marvin. As I said earlier, this is an effort to discredit the information. And I'm not going to say exactly what form the discrediting will take place, But I want to put it out there for when the Guyanese people see that it occurs, because you may well hear, coming from the newly appointed Commissioner of Police, Mr. Clifton Hicken, and his subordinates, that simply this is a situation where none of the information that we submitted can be verified.
Although it's already been verified.
Although it has been verified, I don't think that we could put these things beyond the imagination and the gumption of Mr. Nandalal and the PPP to seek only to discredit the information. We have to bear in mind also, too, Morvin, that recently certain commissioners would have been sworn in as part of a commission of inquiry to investigate.
I want us to come to that as a substantive issue.
Well, I'll stop at this point.
Yeah. Now, things happen strangely. One day, the holder of the highest office in the land said, before the sun sets, I will name a commission. The sun set and rose, and he still didn't. And then all of a sudden, he provided some names. There were no terms of reference, no scope of works, nothing whatsoever. And then there was a lull. And within recent days, these esteemed gentlemen took oaths of office. I do not know if there's still terms of reference in place, or whether they will have to develop them. But many citizens feel that this commission of inquiry is really the creation of a facade. This is a smoke screen to hoodwink Guyanese people, to distract from the real issue of two petitions before the court, which obviously the PPP are running from. How lawful is the establishment of such a commission in the face of two matters before the court dealing with the same issues, as well as criminal charges against individuals who have allegedly committed offenses in the same electoral process? How lawful is this commission, and is it going to be challenged?
I'll deal with the illegality first and the lawfulness of the commissions. We have to break it up, Morvin. The first question is whether the president is vested with authority to appoint a commission of inquiry. And the answer to that will be a clear and short yes.
Yes.
But moving beyond that, an exercise of a power, of a lawful power, in an unlawful manner, or in an unreasonable way, or contrary to the letter or the spirit and intent of the Constitution, could also be rendered and found by a court to be unlawful. And I believe it is in that sort of field that the exercise of the power to appoint a commission of inquiry to conduct an investigation into an electoral matter would fall. Because firstly, the Constitution contemplates that if there is to be an investigation into an electoral matter, that it could be done by two agencies. The first being a court, a duly constituted court under the Constitution, and to hear an election petition. And secondly, I believe that the Constitution, contrary to what the Commission repeatedly says, that the Elections Commission itself is vested with the necessary authority, imbued with that necessary authority to investigate an election. It may not be with a view to upsetting or changing the results of an election, but a commission, even when an election petition has not been filed, would be vested with the necessary authority to investigate what would have happened in an election. Now, when we look at it from that perspective, we must come to the conclusion that the President's exercise of a power to constitute a commission of inquiry to investigate electoral matters falls outside, in my opinion, falls outside the two constituted agencies, the courts and the Commission of Inquiry, and the Elections Commission, and not a Commission of Inquiry. So I don't believe that it is lawful, and a court may well find that the exercise of the power to constitute and appoint a Commission of Inquiry for this purpose may be unlawful. Whether it will be challenged is a matter that the party will have to take further considerations with respect to. But we must bear in mind that challenging these matters is not to preserve only of the APNU AFC coalition. There are citizens who are free to retain counsel and to institute these proceedings. We have a participatory democracy. That is what is written in the Constitution, an inclusive democracy. Never mind that the PPP wants it to be a dictatorial, majoritarian, authoritarian state. That is what is written in the Constitution. And we have to hold the system to account. So there have been persons who have been charged with electoral offenses and matters relating to this, the subject matter, the presumed subject matter of the Commission of Inquiry. Those persons who certainly will have to take legal advice and ought to take legal advice as to how this would impact upon them and their right to a fair trial. I believe that these are very important matters which would not pass through the mind of Anil Nandalal. I don't think that he has the intellectual acumen to objectively analyze these matters. The Attorney General is not the Attorney General of the People's Progressive Party. He's the Attorney General of the state of Guyana. And Mr. Nandalal is devoid of the intellect to appreciate that difference.
It is clear to all that a duly constituted court, when it makes decisions, those decisions are binding on everyone and forms precedent for future similar situations. The question on the minds of the average Guyanese citizen is, are the findings and decisions, if any, because I'm not sure commissions of inquiry would make decisions, but rather recommendations, how binding, if at all, would be the end product of a commission of inquiry? And what is the logic behind having non-binding positions running side by side with court findings and rulings?
Well, that is, you've raised a very important issue, which is the nature of the Commission of Inquiry. And before I deal with the binding and non-binding implications of results or decisions of these two mechanisms, the courts and the Commission of Inquiry, I believe we have to go first to the ground principle, which is, and you will see why, the Commission of Inquiry runs counter in spirit under the Constitution as against the court and the Elections Commission. The court is intended and established by the Constitution, especially Articles 122 or 123, I believe it is, to be an independent agency of the state. The Commission of Inquiry is not established to be by law and imbued necessarily to be an independent agency of the state. I'll explain. When we look at the Elections Commission, it is established expressly in the Constitution to be an independent agent from the other agencies of the state. When we look at the mechanisms for appointment for the Elections Commission and the judiciary, you will see that there is involvement of both sides of the political divide in terms of constituting these agencies. So they start off their constitutional discharge of their responsibilities from a position of presumed participation of both political parties, both sides, the government and the opposition, and therefore it is presumed that they will act in a manner consistent with the constitutional obligations that devolve upon them. When we look at the Commission of Inquiry, it is an executive authority solely. It plays, or there's no responsibility under the current law as it is, but we would have expected in a matter of this nature that it will be more of a bipartisan commission that would have been established. But that has not materialized in these circumstances. And in the nature of the PPP, you would not expect a tribunal or a commission of inquiry being established that would have had meaningful involvement and recommendations by our side, the parliamentary opposition, and the leader of the opposition more particularly. So what they would have done, Mervyn, is to proceed unilaterally exercising powers that vest only in the executive, to appoint persons appointed only by the executive to investigate an electoral matter. When it is put in that context, you see clearly that one, the Guyanese people must reject immediately the constitution of such a commission, and necessarily it foreshadows and casts, in my opinion, a very dark shadow as to what we could expect to come out from this commission, such a commission that has been established and appointed solely by the PPP, solely by the executive of Guyana, solely to investigate an elections in which the PPP has a vested interest. They have a vested interest in creating a new narrative, a narrative that they're innocent and that their hands are free from contamination and participation in electoral fraud. And that is why this commission has been established. The gentlemen are presumably men of repute, but I'm looking at it as a whole, and in my opinion, the Guyanese people would have little to take comfort from the constitution of such a commission.
Let's move to these criminal charges. A number of persons have been charged criminally. Elections, malpractices, fraud, whatever it is, they've been accused of. But others have equally been accused and publicly been accused, including Nandlal. He was accused by officials of the coalition's operation electoral machinery, and that is public. It was alleged that he was distributing identification cards and so on. But he has not been charged. In fact, a number of charges against a number of now government officials, including the holder of the highest office of the land, were discontinued by the Director of Public Prosecution upon these officers taking the oath of office and so on. So on the one hand, there is a clear indication that if you belong to the PPP, you are insulated from possible prosecution, and you're forgiven if the allegations precede your tenure in office. On the other hand, these persons from the coalition of the AP and UAFC are now before the court criminally charged. Is it a case, in your view, that there's legal grounds for these cases, or is it simply a case of a typically vindictive People's Progressive Party?
Marvin, this is a case of a typical vindictive PPP party. What these charges, up to now, almost 2.5 years, there have not been a single statement implicating them that has been published. The courts have not commenced any trials whatsoever in relation to any one of them. They have not gotten a commencement date for the commencement of any trial up to now. The prosecutors are always unprepared to proceed. The prosecutors are never prepared to continue these proceedings. As far as I know, up to now, the prosecution has not revealed and shared as required by law evidence or statements which could possibly be used in a trial. So that is just part of another manifestation of the fact that they just simply want to put members of our party and members of our coalition before the courts for claims and charges that lack substance. You identified, Marvin, persons who would have actually been charged, but I want to expand the discussion to persons who have not been charged, as you mentioned also, but I just want to go a little bit further. In relation to the fact that there would have been 49 ballot boxes on the lower East Coast in which no single statutory document could have been found. No document upon which the Elections Commission itself, during a period of a recount initiated by the Elections Commission itself, could be satisfied as to the contents of that box. One, up to now, has not written the parties that contested that elections, indicating what would have been the results of any investigation in relation to that matter. You have not heard Mr. Nandalal throwing his arms up in the air and screaming and demanding an investigation into those 47 ballot boxes. And that is the distinction between being an attorney general for the country and being an attorney general for your party. Obviously, Mr. Nandalal would have benefited, and his party would have benefited from the 47 ballot boxes or the 49 ballot boxes. Because up to that point of the recount, I believe if you were supposed to exclude those ballot boxes, the results of the elections would have been completely different.
Yeah, I think 14,000 votes were affected.
Exactly. So when Mr. Nandalal goes on his show, Issues in the News, and announced that they won by 14,000 votes, it's 14,000 bogus votes. It's 14,000 votes that the Elections Commission cannot verify by its own process. The Chief Elections Officer said so. That was a report sent to the Commission. That is the state of affairs in this country.
Meanwhile,
so up to now, we've not seen any investigation. The country don't know who are these people that work at these polling places and what happened and why for 47 or 49 ballot boxes nothing is there. Where it went?
Meanwhile, GCOM, courtesy of the chairman, has refused to entertain a motion from 3 commissioners to conduct an internal assessment of its own operations.
But found it appropriate to send information already confirmed
for further investigations, or to be reinvestigated.
To be reinvestigated.
Now, the state has found great difficulty in prosecuting these persons who have been charged with electoral offenses. But the same state machinery has found it very, very easy to appoint, swear in, resource, and facilitate the establishment of a commission of inquiry to inquire into the same elections that these persons have been charged with. Isn't the PPP ashamed of itself? I mean, you can just do these things glaringly. The world is watching and they don't care. What kind of people are we dealing with?
The PPP is not ashamed, Marvin. That is why they're doing it. Because the PPP is incapable of being ashamed. If they were ashamed, they would have been running this country in a fair and equitable manner. The resources are not being distributed in an equitable manner. The access to opportunities are not available to all Guyanese, irrespective of race, class, color, creed, gender, sexual orientation, whatever you want it to be. So we can't expect them to be fair in relation to the fundamental issue which would have them illegitimately in office. They would want to continue to create smoke screens. They want to continue to create the basis for misleading the Guyanese people. And more importantly, Marvin, what the PPP is suffering from and will continue to suffer from it is because they are currently devoid and they have a deficit of legitimacy. Because whether they could seek to do their little sandances here in Guyana at home, the international community continues to question the legitimacy of this government. They continue to question the legitimacy of Irfan Ali as the president, and not because he meets international leaders or leaders from other countries means that they are not questioning the legitimacy of the government. So that is one of their greatest burdens on them. The fact that they're seeking to set up a commission of inquiry in the manner that it would have done is laughable. but at the same time it points out to our supporters, it points out to the citizens of this country the preoccupation of the government at this time.
Now, here is Mr. Nandlal asking these statutory bodies to investigate documents that have already been verified. And that is on the internal front. He goes outside to say in a news article that I saw that he's likely to take legal action against the authorities in Suriname regarding seizure of 3 vessels. Here's the confusion. There seemed to be a competition that exists between Ali and Nandlal. Now, it is alleged that three vessels were somehow taken away from Guyanese fishermen. On the one hand, Ali says that he has written or will write to the chairman of CARICOM, who is the head of state of Suriname. On the other hand, Nandlal says we will sue these people. But neither of these 2 gentlemen, who seem to be going head to head against each other, possibly to become the candidate for the next election, neither of them is saying, let us investigate the allegations against Bharat Jagdeo. Your take.
Marvin, the allegations against Bharat Jagdeo are important, and they're substantial and grave allegations. The country and the world heard them. The people have come to conclusions as to the guilt of Mr. Jagdeo based on what they would have seen in the recordings, device use recordings. And as a lawyer, there's one word that always comes to mind, which judges uses very often in the court system, that of demeanor. So Mr. Jagdeo placed himself in an uncomfortable position in which his statements can be mirrored to that of a witness giving evidence, because he was saying what transpired and what didn't transpire. But the Guyanese people and the citizens of different countries around the world would have come to the conclusion by his demeanor, by his stammering, by his evasiveness, by his whole deportment, that there would have been substance, I believe, to those allegations and those statements made on the broadcast. And it is a very simple thing, very simple thing. We see that this government is against investigations in relation to any matter that they believe that they can't control the investigation and the outcome of the investigation. And that is why I'm warning the Guyanese people and indicating to them to be very careful about this commission of inquiry that has just been established. Because there's no investigation would have been launched in relation to Bharat Jagdeo. They refused to do it. It's public knowledge that a number of investigations are being called for in relation to the distribution of cash grants, the distribution of resources inequitably across the country, in relation to the Guyana police force, which is self-worthy of a proper investigation, but none of them are happening. But they're only preoccupied with putting together an investigation into an electoral matter, in which I believe that they have already proceeded in advance to determine the outcome. I believe the report is probably well written by Mr. Nandlal and prepared and typed at his office.
Waiting release at the appropriate time.
He probably needs to put in the dates now as to when the commission would have sat and which party hacks would have given evidence. But he already has that. He just has to put in the dates now. So this is nothing of substance. It's nothing for us to preoccupy our energies with at this stage. But in terms of its unconstitutionality, we will certainly continue to review it and take it into consideration.
We note well that Nandlal, Ali, and Jagdeo have been beating their chests. And a great legal mind once said that when the law is on your side, you beat the law. When the evidence is on your side, you beat the evidence. And when neither the law nor the evidence is on your side, you beat your chest.
Well, Nandlal has been beating his chest very often.
Yeah.
Probably in need of medical assistance by now.
By now, yeah. Let's move to, there are a number of matters before the court with which you are associated. In particular, there are two petitions, two elections petitions. I gather that in the case of one petition, you have made public that you are awaiting the written decision of the trial judge, I believe the Chief Justice in this case. And that forms the basis for an appeal. I noticed in the news that you've also asked for, and perhaps were granted by now, early hearing of that particular petition. And then there's a second petition which was recently heard at the level, the appeal on the matter of jurisdiction has been heard at the level of the CCJ, and we await a decision on that. Could you update our viewers with respect to the position on these two petitions?
Well, in relation to the last petition you mentioned, the issue appealed by Nandlal after the Court of Appeal rejected his arguments and that of the counsel for Mr. Jagdeo on the question of jurisdiction, the court held that it had jurisdiction to entertain an appeal from a dismissal of the High Court of an election petition. Our jurisprudence can establish no other case where an appeal would have been filed in similar circumstances. So we decided to file the appeal, and we were pleased that the Court of Appeal understood our submissions and appreciated and accepted them, that there was merit in the contention that an appeal in relation to the election petition that was dismissed would lie to the Court of Appeal. And that is not a situation where the petitioner in those circumstances must be devoid or be deprived of the right of appeal when the law in fact provided the appeal, the right of appeal. So it had never been done before, but that doesn't mean that it could not have been done. And we pursued it, and the Court of Appeal agreed with us. Nandlal and company, being dissatisfied with that decision of the Court of Appeal, proceeded to appeal to the court, the CCJ. The CCJ reviewed arguments, heard arguments, as you know, some I believe that was in July. And we await a decision from the court on the question of jurisdiction. I remain optimistic. You could never predict a court's decision, but I remain optimistic that the court may well find that the Court of Appeal is possessed with the necessary jurisdiction under the necessary laws to entertain an appeal in the circumstances that I would have outlined. In relation to the other petition, that is currently before the Court of Appeal. We filed the appeal after the Chief Justice acting, Ms. Roxanne George Wilshire, found that we didn't have enough to proceed to the petition in terms of the arguments. We disagreed with her. We filed the appeal, and for nearly 18 to 19 months, despite my best efforts, quietly by communication, formal communication, by letters and otherwise, we could not obtain the decision from the court, which is necessary to constitute a record of appeal and for the court to review. After considering the matter, I felt that we have to go ahead. This matter is too much at stake, and I filed a motion to the Court of Appeal, which shortly after it was filed, within 2 to 3 days, I received communication from the Court of Appeal indicating that they are prepared to hear the application on the 2nd of October, the 2nd or 3rd of October, I believe. So on that date, we will hear the motion for an expedited and early hearing of that appeal, and we'll take it from there. So that would be the position in relation to the two election petition matters.
Is there a time by which you anticipate the CCJ may be inclined to?
I'm not in a position to say how long more the court will need or will require to complete a decision.
But the sentiments you expressed with respect to that particular petition, I think it's 99, the one before CCJ.
Yes.
People have called me up and expressed the view that it is because of a certain level of anxiety on the part of the People's Progressive Party with respect to the possible nature of that eminent decision. It is because of that fear that the People's Progressive Party has embarked on two things. One, stymieing all efforts to obtain a clean voters list, and two, doling out without accountability and in a very discriminatory manner, and also creating major inequalities with the manner in which they dole out millions, hundreds of millions of dollars in cash grants as a form of an early political campaign launch, a voter procurement mechanism. And many people anticipate very early national and regional elections because of the fear at the front of the minds of the People's Progressive Party regarding a possible decision on Petition 99. What's your reaction to that?
I believe that the PPP, and I've said it, they're very afraid of these petitions being heard, especially petition number 99. Petition number 99, on any page of the petition you turn to, it outlines the fraud perpetuated at these elections by the PPP. It outlines anomalies, irregularities that were permitted by the Elections Commission as an agency. It indicates the insufficient attention that was paid to the Elections Commission, by the Elections Commission, to the entire electoral process. It chronicles the issues in relation to the issues that we are still grappling with, which is a credible voters list, which is at the center of this process. So these are matters which are not going to go away, but they are matters which will become more worrying for the PPP should the CCJ decide that the Court of Appeal has jurisdiction and the Court of Appeal proceeds to hear this appeal very quickly. Because the substance of the decision of the Chief Justice as to why she dismissed the petition is without any merit and substance. There's an allegation that Mr. Granger wasn't served or wasn't served in time. Mr. Granger swore an affidavit, which is before the court, which he indicated when he was served. Those are matters which were not seriously considered and the weight that is supposed to be given to them taken into consideration by the Chief Justice, in my respect. So we are at this point. It is alarming that such a decision would have been given having regard to matters of such an importance, but this is where we are. And as a mature political party, we continue to press our case forward, press our issues forward, whilst at the same time educating the people on the ground for them to understand what is happening in terms of the overall system, the overall sloth, in the judicial system, whilst drawing their attention to the fact that the PPP simply wants to spend in a reckless and high-handed manner the resources of the state only for political purposes. Because none of these things are being done for the benefit of the Guyanese people. The ad hoc nature of the cash grants, the way in which they are obscure, the way in which they lack accountability, transparency, is inimical to the very interests of the people that you're trying to give it to. Because the people of the country are entitled to know, and not only to receive a cash grant, but they're entitled to know under what circumstances Parliament would have allocated these funds and under what circumstances would have been distributed. Up to now, we're still waiting for reports and audited reports from the Auditor General's Department to be laid in Parliament in relation to cash grants. We have Fisher Folk distribution now. So you understand, Morvin, that it's not that our political party is against cash grants, but we are against the distribution of cash grants in a manner that does not promote accountability. We are against the distribution of cash grants in a manner that does not involve any objective assessment of what is actually being distributed and whether it meets the needs of the people as a whole. So whilst they're going along with their trajectory to push and give handouts, I believe it is all being conditioned and informed by the current state of the affairs in this country at this time.
Quickly, time is going down. If you just joined us, you're tuned to Nationwatch, a production of the People's National Congress Reform. We're discussing the question of legal updates with Mr. Roysdale Ford, Senior Counsel and Member of Parliament, Shadow Minister of Legal Affairs and Attorney General. There are two other matters that are of significance and importance to the listening and viewing public. The question of the matter of the appointment of the police commissioner acting and the appointment of the constitutional commissions, I believe the Police Service Commission and another. Could you just quickly give us an update on those two? And there's another big matter I'd like to discuss after that.
Okay, I'll be brief there. Marvin, this is again another opportunity for our people to connect the dots. And we must understand that the PPP is in a continuous march to trample upon the rights of the Guyanese people, to trample upon the Constitution. They're in a continuous march to put in place an infrastructure pretending that it is in accordance with the Constitution. In relation to the police commissioner, we see the importance of the office of the Commissioner of Police, not necessarily for the preservation of law and order in this country, but for the pure purpose of having a Commissioner of Police that the PPP believes will be compliant, that will be submissive to their demands. And I wait to see what would be the response of Mr. Hicken to investigate what has already been investigated by his predecessor. Because this is now the first public test of Mr. Hicken's subscription to the Constitution, or will he kiss the ring of Irfan Ali and engage in what would be a pantomime to investigate what has already been investigated. So he now has that opportunity to prove himself and what he will do. I have my personal opinion as to what he will do, bearing in mind the effort to ensure that he occupies that office of prominence under the Constitution. And we now see the effort by them to have him there before you launch a commission of inquiry. You see the effort to have him there before you institute and request information from the Chief Elections Officer or the Elections Commission as a whole, or the Chairman of the Elections Commission. So you must have your man in place to bat for you. And that is what the Guyanese people must understand. And when they take a very disinterested approach as to the issues of these constitutional matters, they do themselves more harm. I understand it's very removed and quote oriented and what does have to do with us. But when you look at it holistically, you see that it is all connected in terms of having a commissioner of police who would be submissive to their demands. Now the court ruled in relation to the Police Service Commission that it was not properly constituted. The court rejected again, and it's happening very often these days for Mr. Nandalal. I pity him sometimes because he knows better, or he should know better, but the ignorance grips him when he has to go to court to defend the indefensible. So he went to court saying that the Police Service Commission was properly constituted, and the court rejected that. So currently we do not have a Police Service Commission. Any other service commissions are not in place. None of them are in place. And that matter, we appealed the finding that Mr. Hicken was properly appointed, that it was meaningful consultation between the President and the Leader of the Opposition. That matter is before the Court of Appeal. I filed also an early application for a hearing. The Court of Appeal would have responded, and we are in the process of obtaining that date. So we're pushing these matters through the courts. We expect to be successful as we go forward and to build on these cases.
We have about 5 minutes remaining. The case of the Attorney General of Guyana versus BK Marines Incorporated, Winston Jordan and Colvin Heath London has been determined by Mr. Justice Brassington Reynolds.
Yes.
My notes tell me that they've been struck out with costs.
Yes.
I think $2 million to two of the parties, BK and Winston Jordan. Here is Anil Nandlal on it. Quote, "Most shocking decision I've ever witnessed in my brief career at the bar." Give us your take on Mr. Nandlal and this case, which he has signaled his intention to appeal.
This is the most shocking case ever filed by an Attorney General in the history of Guyana and probably in the entire Caribbean Commonwealth or in the entire Commonwealth. This is the first case that I have found, despite all of my research, where an Attorney General would have filed a matter of this significance and importance, and it would have been struck out on every ground, every single ground in it. The judge pointed out carefully and with great analysis that Mr. Nandalal's arguments are completely without merit. I don't know how much time we have, but I would have taken the opportunity to take you through significant parts of the judgment in which the court said that Mr. Nandalal's arguments were specious. They cannot be supported even by the law or by what he presented to the court in terms of his arguments and his pleadings. The court said on numerous occasions throughout the judgment that Mr. Nandalal failed to plead at paragraph 21. Based on the aforementioned excerpt, the claimant in that case pleaded, among other things, the quantum of the loss and the requisite state of mind. In the instant case, the claimant did not comply with these requirements. So this happened throughout the case. Mr. Nandalal failed to appreciate that NISIL is an independent and separate authority from the state of Guyana, and that he was restricted only by the State Liabilities Act to institute proceedings on behalf of the state. The court dealt with that in the judgment painstakingly. So what is really ridiculous is that Mr. Nandalal could have filed such a case and allow it to stay in the courts for 2 years. You know, we recall, and I want to remind the listeners or the viewers of your program, Marvin, that is not the first time that Mr. Nandalal would have filed a bogus application before the court. As a private lawyer during the electoral period of the recount and the issue in relation to the March 2nd, 2020 general elections, he filed an application. I believe it was in the name of his driver. I can't remember his name. Holidar, in which the Chief Justice eventually demanded of him to proceed with the case or to produce the evidence. You recall that?
I think he withdrew.
And he withdrew after leaving such a matter in the court for 2 years. What has actually happened in this case, Marvin, is that the court has pointed out carefully that Mr. Nandalal is incompetent, And the court, by rejecting this decision, rejecting his argument by this decision, it constitutes a public embarrassment and humiliation of Mr. Nandalal. Every single paragraph of this judgment virtually constitutes a rejection by him of his arguments. So there's nothing strange about what the judge would have done, only to the extent that it is unusual, and this is the first time, that an entire case, point by point, would have been dismissed by the court. And Mr. Nandalal couldn't even come to court in time. Look at it, Marvin. You look at it. Look, this is the last paragraph of the decision. The court found
in any event
that it was statute barred, that it wasn't even a viable claim that could possibly have been filed. So, but he wants to go again in public and try to besmirch the character, the integrity, and the intellect of the judge. This is what he does. The public and us at the bar become very accustomed to his statements, but we must know that this matter here had absolutely no merit and no hope of ever being successful. So Mr. Nandalal probably expected that it was going to be lost away in the court system, in a court system that he continues to ensure is incapable of functioning properly. It continues to be underfunded, and that is where we are.
Thank you very much, Mr. Roysdale Ford, Senior Counsel, Member of Parliament. AG versus BK, Winston Jordan and Colvin Heath, London. Another case of a man's shadow destroying him. Ladies and gentlemen, I thank you very much for joining us on this program today. I'd like to thank you very much, Roysdale, for being here and for leading this conversation on the whole question of legal updates.
Thank you very much, Mark.
I look forward to future opportunities where we can do this again.
You just let me know more.
Sure. Ladies and gentlemen, thank you very much. This has been your program Nationwatch for today. Have a pleasant rest of the week.